what does it get you to be a member of a protected class? What does it require of an employer? So what kinds of activities by employers may not be undertaken on the basis of a protected, of membership in a protected class? Yeah?
Hiring.
Hiring. That's a big one. Yeah.
Promotions.
Promotions, any kind of selection for the employment relationship, whether initially, what else can't you do on the basis of any of these characteristics? Yeah.
Discipline.
Discipline. Including termination, industrial capital punishment, the most significant form of
Salary.
salary. That's a big one. And there are laws that regulate, a variety of laws, supplemental to the EEO laws that deal with salary discrimination. Anything else?
Retaliation.
Retaliation. Okay, and we'll talk about that in a minute. We'll talk about that separately. Yeah.
Harassment.
Harassment. So these are all kinds of employment decisions. These are specific actions taken by an employer. There may be controversy over whether they're legitimate or not legitimate, justified or not justified, discriminatory or not discriminatory, but the thing that's not in dispute is that the employer is making the decision. The employer is taking a step. They're hiring somebody, they're not hiring somebody else. They're firing somebody, they're not firing somebody else. Are there any actions that an employer takes that are not subject to the discrimination prohibition? Are there some decisions an employer can make without worrying about all those protected classes and whether or not they're making a decision based on that?
Well,
Yeah.
They just want to close their business.
If they're doing it on the basis of...
Nobody can make them reopen because they did it because all their employees were black.
Well, that's an interesting question. If you close your business, and if it can be proved that you close your business because you're a bigot and you want to get rid of all the people of color working there, is that illegal? Might be hard to prove, but that way, you can't do that. But this notion that there should be a workplace that doesn't have indicia of differentiation based on historical discrimination. And that phrase was used in Title VII to say basically your workplace should not have terms and conditions that differentiate based on protected classes. So if all the white employees get the good lunchroom and all the employees of color get the bad lunchroom, not as significant obviously to somebody's life as being fired, but sort of an index of treating people differently based on class. So in general, any terms and conditions of employment can be challenged. It's actually a decision, I think last week from the appeals court, talking about, placement of offices.
Yeah.
It's a very interesting decision. People don't usually sue over things like that. And there were other things going on in the case as well, but the way the employer organizes and manages its workplace, from the major decisions to other decisions, is something that's covered by these laws. Now, a few minutes ago, somebody mentioned retaliation. What's retaliation? Kind of a whole sort of slightly different category. Yeah?
Taking an adverse action against somebody because they exercise their rights under the statute.
Retaliation. Yeah. So that is kind of an offshoot of discrimination law. And the idea is, if you file a claim of discrimination, if you make a claim of any of these forms of discrimination based on any of these types of employer decisions, can the employer say, okay, we will make your salary the same as everybody else, but then we'll fire you? No. That's not discrimination in the sense they are not doing it because of your race or your age or whatever the original issue might be. They are doing it to punish you, allegedly, for having brought the claim. And that is separately illegal under all the EEO laws, I think probably in every jurisdiction. And interestingly, it is not only widely illegal, it is almost universal that in most cases where somebody is still working someplace and a discrimination claim is brought, it is frequently coupled with a subsequent claim for retaliation. The statistical likelihood of a plaintiff prevailing in a claim of retaliation is significantly higher than the claim of original discrimination, which suggests how difficult it is for both employers and employees to navigate their human relationships in the wake of a discrimination claim being made in the workplace. But now, if somebody makes a claim of discrimination, does that mean you can no longer, if you're an employer, you can't discipline them anymore? You can't give them a bad performance review, anything like that? No. But do you have to make sure that you do that without treating them differently and worse because they've made a claim? Of course you do. Now, suppose the person claims it. Suppose someone makes a claim of discrimination. They say, I was fired because of my gender. Is it possible that a retaliation claim can be brought after that? Even if the person is no longer working there, can the employer retaliate against you in a way that is illegal if you're a former employee? Someone is nodding intelligently in the back row. Explain that.
Giving a negative reference.
Negative reference? That's one example. That's pretty much the classic example. This year, in a case actually that was won by my partner Dahlia, the SJC just ruled definitively, as the U.S. Supreme Court had a few years earlier, that a former employee may bring a retaliation claim, that there are a variety of post-employment employer behaviors that can lead to a successful retaliation claim. If somebody who is an employee has a disability, the employer is obligated to provide reasonable accommodations. That is, if the employee is protected, as you said, if they're able to perform the essential functions of the job with or without reasonable accommodation. So a simple example, you can't say, well, you're in a wheelchair, you can't work here because our doors are 30 inches wide, your wheelchair is 36 inches wide, you can't get in, so we're not going to hire you. You have to widen the doorway. That's a reasonable accommodation. If somebody has a doctor's appointment at a certain time every week or month, you need to give them time off to get to that appointment. That's a reasonable accommodation. At what point does the accommodation become unreasonable? Yeah.
It creates an undue hardship.
Undue burden. Undue hardship? Undue burden. Undue hardship. Undue hardship on the employer. And that, again, unfortunately, for those of us that would like to have simple answers that make cases simple, is generally also very fact-specific determination. So in the case of people with disabilities, the employer has to do more than treat people completely equally. They have to consider what accommodations they need to make in order to permit people with disabilities to fully participate in their workforce. Who else do you have to make reasonable accommodations to besides people with disabilities? Yeah.
Religion.
Religion. What do you have to do in that situation?
I think it's a similar analysis. It's not unduly
undue burden on the employer, as long as they can do it without affecting sort of running their business, then they have to do it.
Yeah, I mean, the bar is a little lower for employers. It's a little easier to justify employer decisions that may affect people's religions. What's the context that typically comes up with religion? Yeah.
You need a Friday night off or Sunday.
Days off, and remember the tattoos, dress codes. I mean, those are the two biggies in the religious accommodation area. Finally, what area of law is very much in the news in the past week, and is one that has led to, in the past 20 years, an explosion of litigation in the EEO area? Yes?
Sexual harassment.
Harassment in general, in particular, sexual harassment. So you have a discrimination claim, and you know you have 300 days to do something about it. Can you walk down to Superior Court and file it? What do you have? Where do you have to start? At the MCAD. Where else can you start?
EEOC.
EEOC. There are administrative exhaustion requirements that are fatal, that if not satisfied, are fatal to any claim. And that means you have to start your case within 300 days at the agency. That really is the ticket to any future successful prosecution of your case. And you can start at either. You can start your case at either agency. Now, then what? Do you say, okay, I've met the 300 days and I've filed at the agencies, now I can relax, no more statute of limitations to worry about for my claim under 151B or Title VII? Or there are other time periods you have to worry about after that? Has anybody had the experience of an MCAD case sort of sitting at the MCAD for years and years and years? And is there any other statute of limitations that arises during that time? Yes, there is. And it is not dependent on the status of the case with MCAD. Many pro se claimants stumble against this. There's a 3-year statute of limitations under Chapter 151B for all cases that, not from when you filed at the MCAD, but from whatever the act of discrimination is that is the subject of your claim. And under the Title VII, just to make life even more complicated, there is no statute of limitations in terms of years, but once the EEOC processes your claim, they will give you what's called a right to sue letter, and you have 90 days to take your case to court after that. So there's lots of different deadlines sort of buzzing around in these cases and I would say a good third to quarter of the jurisprudence that arises in these cases, unfortunately, is not over the merits, but over some of these procedural obstacles. Now, once you file at MCAD, what choices do you have if you were representing the employee? What can happen to that case at that point? Can you leave it at the MCAD? Do you have to take it to court? Can you take it to court? Yeah.
You can choose.
You can choose.
You have a right to ask for removal. I think, is it still after 90 days?
Yeah, and you can ask for it earlier.
Yeah,
You can act discretionarily.
Right.
You can leave it at MCAD, and the MCAD has a dispute resolution system. They decide whether there's probable cause to proceed with the case, and ultimately, if they decide there is, they have a hearing, they make a decision, an administrative law decision, essentially. Or you can take it to court and take it out of the MCAD. What about the EEOC? Can they do the same thing? What does the EEOC do?
They issue you a right to sue.
Yeah, I mean, 90% of the time what they do is they issue you a right to sue letter. They don't have the same dispute resolution mechanism as the MCAD. You could leave your case at the EEOC, no matter what, it would not get resolved, unless it's that rare case where the EEOC as an agency decides to pursue it on its own as a, on its own initiative, but they don't have the legal power, the jurisdiction to actually adjudicate internally claims of discrimination, except for federal employees, which is a whole other system.